from last go around when we had some technical difficulties. My name is Leslie Nino-Piro. I am General Counsel of the Nevada Attorney General's Office. I know I'm the only thing standing between you and lunch, so we're going to try to make this interesting. This is the Nevada Public Records Act. We're going to walk through what the Public Records Act requires, where agencies have discretion, and most importantly, how to document your decisions so they hold up under scrutiny. Okay, so here's an agenda and overview for this next hour. This training is going to focus on what agencies must do, what they may do, and how to document decisions in order to minimize your risk. Now, I'm going to use the term agencies. I know that this is the boards and commissions training, so that just know that I am using them interchangeably to refer to government entities. So the NPRA, as it is lovingly referred, the Nevada Public Records Act, is Nevada's transparency statute. It's broader than its federal counterpart. You may have heard of the Freedom of Information Act. You may see requests from requesters referring to FOIA. But of course, as Nevada agencies and public bodies, we are subject to the NPRA. And the FOIA cases can be informative and persuasive, but they don't control how Nevada courts interpret the NPRA. But of course, they do have a similar purpose. It's transparency for the public. So let's talk for a minute about the purpose of the NPRA. The legislature has made it very clear that access is the rule. That's the purpose of the NPRA. It's not the exception, it is the rule. And exemptions are read narrowly, and agencies bear the burden of justifying a withholding. So we need to show our work in every single response, particularly when we're redacting or withholding any records. So what exactly is a public record? Well, I don't have a comprehensive, definitive answer for you. But a public record is not really defined by the format or the label. If it's created or received to conduct public business and kept as evidence of that activity, then it is presumptively a public record. Public records are created or received by the agency. They're used to transact public business and then maintained by the agency as evidence of that activity. This can be papers, maps, photographs, financial statements, recorded media, and other materials. But the important thing here is that it has to relate to the provision of a public service, the service that the agency provides. So I'm going to give you some examples here within my own office of different types of public records: forms, complaints, contracts, agendas, minutes. You can see there's quite a few. I won't go through the entire list, but it's important to note that records are not limited to just paper. They include paper and digital files, anything which comprises written, recorded, or graphic matter in physical or electronic form. So what's not a public record? Let's talk about what is outside of what we would consider evidence of an agency's activity. And this is a general guide that comes out of the Nevada Administrative Code. Not everything in an agency's possession is a public record. So reference materials, purely personal items, and convenience copies generally fall outside of the NPRA. So any non-record materials or any documentation that does not serve as the record of an agency's official action. And just remember that it's not the labels that control, it's the content and use. So I want to spend a minute talking about document retention, because it goes hand in hand with our obligations under the Public Records Act. Records management is the classification and storage of records according to a set schedule. And that set schedule then instructs the disposal or archiving of those records. So how are those schedules determined? Retention periods are based on state and federal regulatory requirements, statute of limitations, and best practices. So retention schedules will tell us how long to keep the records, but they won't decide whether a record is disclosable under the NPRA, and they certainly won't override our disclosure obligations. So if an agency holds on to a particular record for 20 years and then it's requested, it needs to be disclosed. So it is important that we're taking a look at our retention schedules and seeing exactly when the trigger is to do something with it. So no record should be kept by an agency forever. So that's why it's really important for us to see what our retention schedule is. And the best motivation for complying with that schedule from a public records perspective is that when you are regularly making sure that you're compliant with your schedule, then there's less to search and less to review. So, which records are subject to public records requests? Well, the legislature has told us that we start from the point where all agency records are public, unless it's declared confidential under Nevada law, statutes, or case law. So there's a strong presumption that a record is open to the public. So a quick note on how public records requests are submitted to our offices. The NPRA allows for both written and verbal requests. So you're required to have a form on your website that allows for a public records request. It's far better to have that in writing to see exactly what it is that the requester is looking for. But you also have to have the availability for persons to either walk in or especially over the phone to be able to make the request in a different way. So let's talk about probably the most important obligation under the NPRA. Within 5 business days, agencies must respond in writing, and that response can be either a release, a no records response, we don't have anything, we've searched and we don't have anything, a referral to another agency, or you acknowledge the request and provide an estimated response date. And a note with an estimated response date, it's best to provide a specific date rather than just a range of dates or, in 30 days. It's better for everyone, easier for your staff if you're calendaring to make sure that you have that specific date. And it should reflect the earliest date that the agency reasonably believes the record will be available. So this is in concert with the statutory obligations for us to provide records and to do so in a timely manner. Now, don't worry. I know that 5 days or even sometimes we get overwhelmed with requests and we need additional time. That date can be adjusted in the future. So written communications are required by the NPRA, and I recommend that you have a log or you're keeping some sort of internal record to show what exactly you're doing with your public records requests. When we must respond within 5 days, we get a lot of folks coming back, and sometimes we'll say within the 5 days, okay, here is the reasonably anticipated date in which this record is going to be available. And we'll get responses back from requesters demanding that the NPRA says it must be provided within 5 days. Now, in these days of understaffing and having to conduct confidentiality reviews and privilege reviews, many times it's just not possible, particularly with the broad requests that we received. So it's important to note, don't get ruffled by those types of demands. The NPRA specifies, or the Nevada Administrative Code specifies, that record readily available under the NPRA means it's easily retrievable by an employee, It does not contain confidential information. So that is presuming that you've, you know, right off the bat that there's nothing, no personally identifying information in there or nothing that's confidential. And it's not the type of record that would require review to determine whether the record includes confidential information. So I would recommend that if you have frequently requested records within your agency, think about perhaps having a spot on your website where you would post those frequently requested materials. So for example, several years ago, the AG's office was receiving just a onslaught of records requests having to do with the opioid settlements. So the Bureau of Consumer Protection in our office worked with our IT to create a website where a couple of website pages where that information was provided. And then that is going to cut down on the volume of your requests. And then of course, the review that you must do for every single request that comes in. So requests for clarification. If a request is unclear or it's overbroad, meaning they are asking for production of records anywhere the issues were ever discussed or even vaguely mentioned, I would consider that a pretty overbroad request. So we should be seeking clarification for each one of those requests. And it's not a denial to ask for clarification. It's part of our duty under the statute to assist the requester in getting what they're looking for in the most timely and efficient manner. So I frequently get questions on exactly how we ask requesters to clarify. Sometimes it's a little bit difficult to articulate to them what exactly it is that we need to process their request. So here's 5 specific ways that you can ask for clarification from a requester. Ask them for the name, the category of records that they are seeking. So if they're looking for complaints or something of that nature, ask them specifically the types of documents they're looking for. If they know the people who are involved, the participants, sometimes you'll get a list where they'll be very, very specific and asking for by position and title. That is always helpful. You can ask for email addresses, domain names. If they're just saying, I want all records of communications between your office and X public advocacy group, let's just say the ACLU, for example, you can ask them specifically for a domain name that they're looking for, that they believe maybe there are communications available. Your goal is to find to get down to a very targeted search. And that's a goal for both us and the requesters. Of course, for us, it's less time to review, less time to redact. And if your agency imposes fees for research fees, it's going to be less charges for the requester, and it's going to get to them faster. So this is a goal that assists everyone in this process. So here's a model process for public records requests. And I will, with the caveat of saying, make sure that you have an agency-specific protocol that you develop with your counsel. Agencies should follow a very consistent, documented process from logging the request to then searching, applying statutory exemptions, privileges, or going through a balancing test. Starting out with the log, your searches, and making sure that you have your process documented throughout your agency. And anyone who is working with your public records requests is very familiar with this process and follows it. So at the tail end of this, you're making sure that you're going through the balancing tests, and confer with your agency counsel if you have questions as to whether or not records are disclosable or whether or not any redactions are necessary. Closely following your agency's policies and procedures is the best protection that you have against the mayhem of unexpected litigation. So I'm going to dive a little bit deeper into each one of those steps, and we'll start with statutory authority to withhold records or to redact. If a statute makes a record confidential, that means that the NPRA does not apply. So you may have noticed in NRS 239010, there is a very long list of statutes that are considered exempt from the NPRA, exempt for certain categories of information. Now, what I have found in working with agencies all over the state is that most of the folks in agencies, they know their own chapter, as they should, right? So you should be very familiar with your chapter, know exactly what confidentiality provisions are most often applicable to records within your agency. And be sure when you are providing your responses to any requesters and you are going to withhold records on that basis, that you cite both that provision of Nevada law within your own statute and also cite this 239.010. Be on the lookout for any federal provisions, which may also provide confidentiality protections for some of your records. So moving on to regulations, which may also have provisions requiring or at least offering confidentiality. But if confidentiality is based on a regulation or on common law, balancing is still almost always required. And that's because the Nevada Supreme Court has told us that the Nevada Administrative Code does not limit the scope of the NPRA. So we frequently get these types of questions, in particular with having to do with personnel records. So I recommend not simply citing the administrative code, but also going through the balancing test, particularly if there's personally identifying information involved, and being very specific as to why there is harm and tie that back to the underlying information within the record. Keep in mind that regulations alone do not shrink the NPRA. The balancing will still apply. So let's talk about that balancing test. So what do agencies do when no statute declares a requested record confidential? They need to weigh the interests. The government must show that the agency's interest in secrecy clearly outweighs the public's interest in access. So you may hear this sometimes referred to as the Bradshaw test or the Gibbons test, but there's no question that it is a balancing of interests. And we're required to show our work. So you need to, in your responses, let the requester know exactly that you are relying on this test and any other applicable case law or administrative code. Note that the government has the burden of proof in the general balancing test, but the burden shifts to the requester in cases where the government asserts a personal privacy interest. So let's talk about that. So this test is sometimes referred to by the federal case, which the Nevada Supreme Court relied upon to come up with this balancing test, which is Cameron-Essie. In cases where the government establishes a personal privacy interest, and it's a two-step test, then the burden shifts to the requester. So in step one, the government needs to establish a non-trivial personal privacy interest. So it can't be a nothing burger. It has to be a true privacy interest, and it has to be more than de minimis. Now, these are really very legalistic words that I don't want to necessarily get caught up on. It's important to know that we have examples in other statutes and regulations as to what exactly personal privacy information is. And if the government establishes that privacy interest, then the burden shifts to the requester to show that disclosure of that information is likely to advance a significant public interest. So since relying on Camera and Nessie to establish this test, the Nevada Supreme Court has reaffirmed the personal privacy balancing test in multiple different scenarios. The test applies whenever the government is asserting a personal privacy interest, even if it's behalf on a third party. Now, the threshold to show that it's a non-trivial privacy interest is low. That's why I say don't get too caught up on that. Like, is this a good enough privacy interest? The government should not be forced to wait for a serious harm from unwanted intrusion of personal privacy in order to justify non-disclosure. So this is a pretty broad balancing test. It is not impenetrable, but it is a very strong tool in our arsenal as agencies for what can be protected. So if you have gone through all of your searching and reviewing, you've talked to counsel and you decide that you're going to deny a request or withhold records, any denial must cite specific legal authority to withhold those records. So let's start out with going through your statutes or regulatory authority. I've mentioned that you should do a balancing analysis if you're relying strictly on administrative codes. Then you're going to go through some of the common law doctrines, which includes all types of legal privileges. A couple of those I'll mention: deliberative process privilege, official information privilege, and then, of course, you have the balancing test also that you could look to, even if there wasn't either a privilege, a statute, or an administrative code. So after an NPR, well, let's talk about beforehand. Many times we get a request with initial language that says, look, if you're going to withhold anything, then you need to provide a log. Sometimes they call it a Vaughan index, which is a term that's used often in FOIA litigation. Essentially what it is a privilege log. They want to know exactly what it is that you withheld and your analysis for doing so. It's important to remember that Nevada case law has said that we are not required to provide a privilege log at the outset of a response when you're withholding. That is not, does not become more of a requirement until litigation has been filed. But even then, a requester may have sufficient information to contest the claim of confidentiality even without a log. So the takeaway from this is that they're generally entitled to a privilege log after they've initiated litigation, but not in every instance. But from a risk management perspective, I encourage agencies to document in an internal log or in memos what exactly was withheld and why, and do that at the same time that you're looking at the request and you're making those decisions. It's a contemporaneous record at the same time when you're processing the records request. And so that's going to help down the line if you ever are engaged in litigation about one of these requests, to show exactly what the agency and the records officer was thinking when making those decisions. So I'm going to take a minute to talk about investigative and law enforcement records. In the last few years, several cases have come out from the Nevada Supreme Court that are dealing with these types of law enforcement records and investigations in particular. It seems to be somewhere that agencies are getting tripped up on the interplay of all of these balancing tests. Generalized assertions just aren't going to cut it. The courts expect specificity. And if we're making blanket claims about investigations and privacy and just very cookie cutter statements, those types of statements rarely survive review. So the two cases that illustrate this are Conrad versus the Reno Police Department, and both of these are 2023 cases. The next one is the Las Vegas Review-Journal versus the Las Vegas Metropolitan Police Department. Now, what's interesting to me about both of these cases, one was a pretrial case, so you would think that a defendant's right to a free and fair trial would have a little bit more weight. the Las Vegas Metro case was a closed investigation. So theoretically, there's a little bit of less of a privacy interest that's involved there, but there was no charges that came out of that investigation. So we like to think that, if you were investigated for a crime and it did not result in actual charges, that there would be a bit of a stigma attached to that, and that we would want to provide additional privacy protections for that person. In both of these cases, what's the important takeaway here is that the court found that there was not a specific and detailed explanation of the risks and harms that could stem from disclosure. And this was even though there was affidavits provided by officers from both the Reno PD and from Las Vegas Metro. And the court still found that either the court's findings weren't specific enough, or the officers had not provided enough information and tied it back to not just your cookie cutter, well, this is, privacy. We've got to have more. And also an explanation as to why you can't redact. Why can you not cut out the private information and still provide something to the requester? This is why I am very much in favor of a redact and release approach. Of redact, redact. Your decisions to withhold come under much higher scrutiny than redacting the information, even if maybe there could be some disputes as to whether or not it was over redacted. Simply withholding documents, we've seen time and time again from the Nevada Supreme Court that is not their preferred method of seeing agencies respond to requests. But I do want to give one footnote here that the RAGA, the Republican Attorney General's Association versus Las Vegas Metro, in that case, the Nevada Supreme Court found that a withholding in full was appropriate, where the confidential material was inextricably commingled and redaction just wouldn't have left anything left. But I also want to point out that case involved juvenile justice records. So, it had a very strong statutory confidentiality provision. And the court actually took a look at that video, the officer's body cam, and said, there just really would be nothing left if we tried to redact out. Okay, so I'm going to go through a very helpful checklist for you as you're responding to public records requests. I like to think of it, since we're close to the Super Bowl, in football terms, I like to think of it as going through my progressions to see how we're going to respond to requests. So number one question here, is the requester actually looking for records? Many times it is quite common, we will get a request and they're really looking for information. Now, granted, maybe that information is contained in records, but we won't know unless we know exactly what records it is that we need to search for. So that's the first and very important distinction. Is it records that they're looking for, or is it information? Agencies don't have a duty to create a new record. But if the information that they're looking for is maintained in a database or some type of internal files, and you can just press a button and run a report, then that information is going to be deemed a record. So keep that in mind. We do as much as we can to give requesters the information that's in our custody and control. So the second question to ask there is, do these types of records exist? There's times that requesters will be looking for something that it's just not something that your agency tracks, or maybe it's something another agency tracks, but not yours. And so that leads into question number 3. Do we have legal custody or control of the requested records? So an example here, my office frequently gets records requests for marriage certificates, death certificates, things that and sometimes they'll even mention within their request that they're looking for an arrest report from Nevada Highway Patrol or an investigation report from Las Vegas Metro. Well, it's very clear that we do not have the documents within our custody and control. And so We then issue a referral to that person and let them know if you can reasonably determine exactly, if they say right there in the request that they're looking for an NHP arrest report, I know exactly where to send them. And the other important thing to note about this is that we do our best not to decide privileges or withholdings for other agencies. Many times we wouldn't even have standing to do that. So it's important that if your agency was not the one that created the record, maybe you happen to have it in your file, many times it's a good idea to just go ahead and refer that requester over to the agency with the legal custody or control of the document. Okay, so next, ask yourself, is there any common law privileges or confidentiality doctrines that may apply? So deliberative process privilege is one that comes to mind. Common interest privilege for our office, that is a big one because we do a lot of work with multi-state attorneys general throughout the country. The official information privilege, these are all things that are not necessarily statutes or regulations or even that balancing test, but they do have plenty of precedent under Nevada law. Then you're going to look at the balancing tests. Is there a reason that we need to look to see whether the balance of interest weighs in favor of the government, particularly where personal privacy interests are in question? And then, is it something that we're going to need to withhold altogether? So similar to that Raga case where the juvenile justice information was just inextricably commingled, was just all over the place. There was no way to redact it out. And so that is just dovetails with the eighth question there. Can you really redact? It may take some time, but can you redact and provide the record, even if it's not going to be a whole lot there? It's always easier to defend narrowly tailored redactions than a blanket withholding. So I'm gonna have the slide here that talks about some common personal privacy or PIIs, you might hear it referred to. The ones that I think everyone can name right off the bat: a person's name, their address, their social security number, telephone number. But there are others that are, if you think about it, they make a lot of sense, but they may not come to mind right away. And I like to think of it a little bit also as safety and security can be a part of that. Which goes right along with your home address. We don't want the public having or requester having home address information for every person who either works within the government or even just constituents who are coming to us for help. But what may tie into that you may not think about, like let's say someone is going on a trip and they have a travel expense report and they're using Uber from their home to get to the airport. Those addresses show up in Uber receipts. So it's other places that you should look. There's all types of identifying information that may not be readily, you may not think about it when it comes up. Another one that I like to think about is signatures. We have mail-in ballots here in the state of Nevada, and I don't want anyone having ready access to my signature to practice it and steal my ballot out of my mailbox and then use it. So those are something where even if the document is itself disclosable, we do our best to guard any personal privacy information. And if you have any questions, you'll have this slide after the presentation, but also talk to your counsel. Okay, fees. It is quite controversial amongst particularly news organizations who will frequently criticize the government about some of the fees that are charged. So let's go over them. It's a very contentious issue. If you are going to charge fees, you need to maintain a list of your fees, have those available upon request, or just put them on a website. Anything you can make available on your website, it's one less request that you may have to respond to. And just a quick note on court reporter transcripts that fees are also, the fees may also be applicable there. Do you have a question?
Are we responsible to have our agencies post the fees for the court reporter?
As far as like being counsel for them? Yes. So I would recommend that you make the suggestion, but you can always, this is what I say about client advice to our clients. We can lead a horse to water. They may not do it, but I don't see any specific liability for counsel and not.
Well, not liability for us, but like say like we're at a contested hearing, the attorney is making a stink because we provide the transcript, the court reporter transcript, that they were supposed to reach out to the court reporter. Is it actually our responsibility to have that information available to them, like on our website or whatnot, to get that info?
So court reporters have a very special place in Nevada law. The laws and regulations make sure that they receive compensation for what it is that they are, for the service that they're providing. So that is something that it's the court reporter, herself, who has legal custody and control of that. And if there was, like if our office paid a fee for that court reporter's transcript, they would need to pay a similar fee. I don't think that we have an obligation to, let's say, collect a fee and then provide that onto the court reporter. We can do a little bit more digging though into that question if that's a concern. Okay, yeah, let's look into it a little bit more. So to piggyback on Rosalie's presentation, minutes and recording, there's a statute within Chapter 241 that says that minutes or audio recordings of meetings have to be made available within 30 days. The best practice is to go ahead and have those minutes available to the public online, and it's going to minimize the number of unnecessary requests that you're responding to. So let's get in a little bit more into the meat of actual costs. So the public bodies who fund our positions within our office, they certainly expect us to respond to public records requests as a part of our regular duties, but they don't necessarily fund specific positions for public records requests. And that doesn't really add up, right? Because each one of us outside of our public records duties and responsibilities has a full 40 hours worth of work. So there was an extraordinary use provision that was in Nevada law prior to 2019, but many advocates, transparency advocates, felt that those fees were being abused by agencies. So there was a pretty big shift in 2019 when the legislature replaced the term extraordinary use with actual costs. So what is the actual costs? They're going to include the direct costs of responding to a records request. So the examples provided in the statute are ink, toner, paper, things of that nature. But I want to be clear, I've heard some of the news organizations report that because the statute doesn't explicitly say that agencies are allowed to charge for labor fees or research fees, there's been reports that agencies have created a loophole to charge for labor that it may take to provide a public record. I think that interpretation or that suggestion is absolutely false. If you go back and take a look at the legislative minutes from 2019, there were many folks who testified in front of the legislature talked about, gave very specific examples of organizations that were requesting tens of thousands of documents, that employees were working weekends to respond to public records requests. And an agency was even forced to invest in another printer to make copies for a 10,000 plus page request. So the legislature expressly considered in an amendment that was requested to exclude overhead and personnel, and they rejected that suggestion. So although the statute does not specifically include labor as a part of those examples there, ink, toner, paper, and whatnot. The legislature's found that such costs may be appropriate when requests are incredibly onerous and incredibly large. And I will tell you, it feels like every single request that comes into my office these days is incredibly onerous and incredibly large. The agencies have flexibility to recoup their costs for very broad requests. And the reason for that, and at least in my estimation, is that the legislature didn't want the taxpayers bearing the cost of public records requests, that it's a service that the government provides, just like many other government services, and that it should be borne by the requester. Should be their responsibility to pay for these additional costs. One last quick note, I have come across different policies and different entities that still reference extraordinary use language. So that was repealed 6 years ago. I highly recommend just take a quick look at your policies and make sure that terminology is not still included. So I want to break down this concept of actual costs just a little bit more. They are not supposed to include any costs which an agency is going to have no matter what. The reason for that is that the legislature wanted to discourage agencies from depending on fees to fill in any budget gaps. So actual costs means documented, actual, but variable costs, and they can't be arbitrary and they can't be used to deter requesters. So think of fixed costs as predictable. What does an agency know that they're going to have to pay regardless? Office space, utilities. If you have business software like Microsoft Office 365, Adobe, you're going to have those subscriptions regardless of whether or not you have public records requests. Variable costs, those are going to fluctuate. Those are directly attributable to a particular public records request. So yes, production supplies like ink, toner, paper, discs, thumb drives, all of that could be directly attributable to a request, postage, of course, but also labor, because in the absence of that request, our attorneys would not be spending time doing a privilege review or going over a request. So that is, at least in my analysis, is what the legislature meant when we're talking about actual costs. So the takeaway, they shouldn't be set at an arbitrary amount. You want to make sure that you're not even at what the agency thinks is fair or reasonable. Do some research within your own agencies, find out what hourly, what some of the folks who are handling your public records requests, what would their salary break down to, find out how much you're paying for paper, and at least document that. And so if your fees are ever challenged, then at least you have something that you have documented within your agency that's going to tether that fee to an actual cost. Okay, so we've responded to a public records request. Let's say we've done some redactions. Maybe there's been documents withheld and the requester is not happy. Their option is to, they have a couple of options. Go to the district court when if request was denied or a portion of their request was denied, if they feel the request was unreasonably delayed, or for excessive and improper fees. So the courts can compel disclosure, they can adjust fees, award attorneys' fees, but agencies that are acting in good faith and employees who are acting in good faith are protected from damages. So I do want you to relax. If you're just doing your job, you're worried that you're going to have damages imposed against you. That is incredibly rare. If you were doing your job in good faith, you should be okay. But it's important to be aware that the statutes that were passed in 2019 added civil penalties as one of the tools in the toolbox for requesters and for the courts. So if there's, for violations, an agency could have civil penalties assessed for, first, second, third, the price just goes up. So it's very important to know that these are at least out there and that you're following policies within your own entity. So this is a recent Nevada Supreme Court case. It is unpublished, so it's persuasive. It's not binding precedent, but I do think it's important to talk about what the court did here. A requester, a pretty well-known and frequent requester, was arguing that the Washoe County violated that 5-day rule because they had an automated response that said, okay, we're acknowledging that you have a request and we're going to get back to you within 30 days. And he said, no, you have to search and review and give me records within 5 days. The court said that the NPRA doesn't say anywhere that you're not allowed to do an automated response. And there's no prohibition on predetermination of delay to know from the outset that, hey, I'm not going to be able to have this within 5 days. That is not violating the NPRA. I can tell you right now, even within my own office, it is very rare when we're able to get something out within 5 days because we have hundreds of requests that we're dealing with. So I want to make sure that this agencies know about this decision and that the Nevada Supreme Court is at least looking at the NPRA and knowing that that is just not the reality in statute, and hopefully they know that it's not the reality in practice. So a couple of key takeaways. The NPRA already anticipates that we're not going to be able to fulfill every request within 5 days. And the county was okay in this particular instance because they sent a response within 5 days. They honored the 5-day rule and they provided a timeline when those records were going to be available. So one other decision to note from last year, Las Vegas Metro Police Department sought a declaratory judgment. There was requests for records about an investigation. Of course, this is the police department, and it was very salacious because this had to do with a professional soccer player that many of you probably know. So Metro felt like we're not quite sure what our obligations are in this situation. So they tried a very novel approach. They tried to take it to the court and get a declaratory judgment on this. Court, you tell us, what are we supposed to do with these records? Unfortunately, the court found that the police department could not seek an advisory opinion, said that those particular statutes that provide for advisory opinions did not apply in the public records context and did not apply specifically to the police department. So that is not, that's not an avenue for us to, for better or for worse, that is not an avenue for us to get an advisory opinion from the court. A couple of new legislation to make sure that you're at least aware of. And I trust that all of you have gone through your own statutes and know what changes were made there. But these are a few just to make sure that you may have gone through. Donors, members, volunteers of a nonprofit organization, government entities need to keep their information confidential. It's private, personal information that we are required to keep confidential. Other records under Nevada law were either made public, and so the legislature said very explicitly, nope, this is a public record. It is subject to public inspection. Or one that I thought was kind of curious to me, the contracts related to name, image, and likeness materials were specifically excluded from public records disclosures. And then also kind of a mixture hybrid of the two, candidates' proof of identity or residency, those are public records, but of course, any information within it that would be personally identifying is not public. So I'm going to end on a happier note, I hope. AB 128 created a public records task force. So the task force was put together to evaluate the NPRA. How is it actually working in practice, so that we can make recommendations to the legislature in the next session for potential changes. So there's a pretty long list there of different topics that they specifically mentioned that they would like the task force to take a look at. And then at the end of this process, towards the end of this year, we're going to submit a written report describing our work and then recommendations for the legislature. So think about these as long-term improvements to the NPRA. Some of the recommendations that they're looking for, like it is a little bit of a heavy lift, but I think it's high time that we take a good look at the NPRA and see how we can make it better for both requesters and for government entities. Because certainly requests can be taxing on many agencies in terms of time. They're taking more and more time to fulfill, and the NPRA has a lot of gaps, leaves a lot of questions unanswered. So hopefully we will be able to answer some of these questions. I have a list here of the folks who have been appointed to the Public Records Task Force. Our first meeting is tentatively scheduled for next month, towards the end of next month. And if you are interested in helping us improve the NPRA, or if you would just like to get some updates and know what's going on, please feel free to email AG General Counsel at ag.mv.gov, and I'll make sure that you have those materials and information. Okay. Does anyone have any questions? Anyone in Carson? Looks like.
Is that any better? Oh, wow, for
Yay!
everybody, okay.
Okay, yes, we can hear.
Thank you very much for your presentation. I had a question about the deliberative process privilege. It's one of those privileges that I've kind of never been able to wrap my mind around. Would you have any comments or a better summary of that privilege?
So I'll give you my off-the-cuff memory of some of the requirements in the deliberative process privilege. So it's meant to protect the decision-making process for agency heads and public officials. So, it's one of, you may have heard the phrase very often that like, there's no dumb questions or something like that. So it's meant to protect that, because sometimes the conversations or maybe reports to the agency head that are within the time that they're thinking about, like, what am I going to do to institute this policy? That is what is meant to be protected. Now, just straight factual information, that is not protected. It is the deliberative process, hence deliberative process privilege, but it is the discussions around the ultimate policy. So, for instance, I'll give you an example of when one time when I used deliberative process privilege, when the Nevada Department of Corrections was looking at putting together an execution protocol. All of the discussions leading up to and the legal advice that we provided in relation to that process, those were privileged. As soon as that policy was issued, as soon as it was signed by the director, that privilege is no longer going to protect communications regarding the policy and subject matter. So it's important to be clear that what it protects there's no dumb question and there's no dumb, no dumb advice. Well, there could be some dumb advice, but we're at least saying that is not contributing to the public discourse. And once the policy comes out, if an agency head goes and talks about it later on, those types of conversations are not going to be protected because the policy was issued.
Okay.
I hope that helps to answer.
Yeah, no, that's very helpful. So sorry, just to sum up what you're saying. So the pre-decisional deliberations of a policy that has been issued are no longer confidential.
No, that's not what I'm saying.
Oh.
I'm saying that if they talk about it after the policy is instituted, then those conversations are not going to, so that whatever happened leading up to the decision point, that is still protected.
Okay, great. Thank you very much.
Of course. Yes.
This is kind of a personal question, but on SB 293, would that include contracts where public institutions compensate athletes?
That's my understanding, is that it's, yes, that it's within their chapter for where universities, institutions of higher learning are creating contracts with student athletes. Not my area, but that's my reading of the statute.
Maybe?
I apologize. I don't know what that is. Any other questions?
Hi, I have a question here from Carson City. So you mentioned if you have documents on the website, maybe you'll get fewer requests, but what if people still request things that you do have on the website? Can you just provide them the link, or do you still need to provide them a copy of the record?
That's exactly what we do, is we respond with the link, particularly if we're responding via email. If they ask for a copy of the materials, I would look at it then as, depending on whether or not your agency has a fee schedule set up, would you then have to charge them postage in order to send it out? You can certainly have those types of conversations, because I think 99 times out of 100, they just don't know that the information is online, and a link will suffice. Great questions.
I'm just going to follow up for everybody really quick. So I don't know if you heard my previous question. So I had half of it answered for open meeting law, but my second part of my question is, so say for a meeting that's recorded, audio and video, if you are unable to provide the video recording as requested by this person, but you can provide them the audio because the video portion contains closed session items that you can't redact. Is it a violation if you're only providing audio when they've requested video?
So my general interpretation and thoughts on that is that no, it's not a violation. The NPRA does not. We get a lot of requests sometimes from particularly commercial requesters that are like trying to build databases of commercial information, and so they will say, "We want this in Excel format. We want this in the exact format in which you kept it." And that is not what the NPRA requires. There's a distinction between electronic records and paper records, but an Adobe PDF is an electronic record. That is a record which I am able to redact confidential information, personal privacy information. It is still in an electronic format, but there is nothing in the NPRA that says you must provide in a native format, that you must provide in any particular format. So if you're providing the copy of the meeting audio, but not video, my interpretation is that there's nothing in the NPRA that says, no, you got to give them the video. Any other questions? Okay, so I do have a QR code. Whoops. That's up on the screen here. If you're seeking CLE credit, please note these are recorded and they're going to be going up online at some point in the future, but the CLE credit is only going to be for those who participate in the live training, whether it's on Zoom or you're here in person. You should get a little bonus for being here in person. And if you've registered for the training, you're also going to receive these links for all the presentations via email. So don't fret if you don't catch it right at the second. Thanks so much for your attention. You guys are on at lunchtime now.